Welcome back. You're still watching the Afia Morning Show, and thank you once again for staying with us. It is, well, finally the end of the week. For many of you, I'm sure you're getting ready to party. For some of us, it's time to sleep. But not before we discuss the fresh developments in the case of the detained IPOB leader, Mazi Nnamdi Kanu. Now, many of us recall that the leader of the Indigenous People of Biafra, that's IPOB, Mazi Nnamdi Kanu, yesterday visited the Supreme Court in Abuja to personally submit a letter to the Chief Justice of Nigeria, Kudirat Kekere-Ekun. Now, Kanu wants the CJN to discontinue his ongoing terrorism trial at the Abuja Federal High Court, citing a repealed law. His arrival at the Supreme Court was part of his, well, last-minute attempts to discontinue his case, which is set for judgment on November 20th. The IPOB leader was accompanied by officials of the Department of State Services, the DSS, of course, as he went ahead to submit that letter. On Wednesday, we'll recall that Kanu had filed an application at the Court of Appeal praying for the stay of further proceedings in his trial before Justice James Omotosho. Now, to discuss the ripple effect of these developments, we're joined in the studio by CEO Sputnet Limited and Public Affairs Analyst, Mr. Chilaka and Njoku, who is also here alongside Barrister Chiagozie Nwabuko, a legal practitioner. Thank you, gentlemen, for joining.
Thank you very much.
Yeah, thank you very much.
It's been a long time. It looks like we've been on a holiday but both of you are back. Thank you once again.
You're most welcome.
So let's start with you, Barrister Nwabuko. I mean, this is a legal case, yes, and we're seeing the developments. Initially, Mazi Kanu, he sacked his legal team, went ahead to continue to defend himself. But now that Justice James Omotosho is set to deliver judgments in just a few days, he is going to the higher courts, the appeal court first, then just yesterday, the Supreme Court, asking for that case, that trial, to be discontinued. What is the possibility of the Chief Justice of Nigeria granting this request?
Well, they moved to the Supreme Court where he gave a letter to that effect. That is not the law. He don't write to the Chief Justice of Nigeria to order a judge to discontinue a case. That is not the law. If you want a case to be discontinued, you file necessary applications in court based on the law. So he cannot write a letter to the CJN asking the CJN to order the Justice Omotosho to discontinue his case. That is not the law. So that one is already discountenanced. For me, I think that one has no force of law whatsoever. Now, where we have an issue is his application at the Court of Appeal, his motion for stay of proceedings. Now, the question I've always asked is this: the stay of proceedings, what is it predicated on? Because the stay of proceeding must be predicated on an appeal. Remember, Justice Omotosho, refused his application for stay of his application for no case submission, and the court ordered him to enter his defense, which he after several adjournments, he refused and declined to take his defense. And then he's gone to Court of Appeal to ask the Court of Appeal by application to stop the Federal High Court from continuing with the matter. For me, the issue is, was there an appeal? If appeal has not been entered, the Court of Appeal will not grant an order staying the proceedings. And the worrisome aspect of this whole thing is that the judgment is just in a couple of days. Now, I learned also that he filed a motion seeking leave to appeal. That means he's already trying to appeal out of time. Assuming he had done it timeously, there would have been a pending appeal. As we speak, there's no pending appeal at the Court of Appeal. When the court refused the application for the no case submission, he would have immediately filed an appeal against that order, refusing the motion for a no case submission. He would have had a proper appeal, which will be predicated on his application for stay of proceedings. So the stay of proceedings is not connected to anything because there is no appeal at the Court of Appeal. That is a problem. He has no defense, one. Two, he has no pending appeal, because if there's an appeal, now the Court of Appeal justices will look at the appeal and say, okay, High Court, stop. We have an appeal before us. Let us hear the appeal first before you continue the trial, which is what I believe Mazi Nnamdi Kanu wants to achieve. But however, there is no appeal pending. Rather, there is a motion for leave within which to appeal, because his appeal is already out of time. Now, that is the problem.
So, does that mean that right now he must stay and receive the sentencing?
What I will advise him to do, if he will listen to me, is to do what? Make an application to reopen his case. he has been foreclosed, right? He still has a right under the rules to apply for his case to be reopened, so he will be allowed to enter his defense. While the defense is on, his appeal will mature. Then he will bring the application for stay of proceedings.
But does that not completely contradict his defense stance, which is that if he asks them to reopen the case, has he not now admitted that there is a case? Because his whole point, his whole defense is that there's no jurisdiction, talking about repealed laws, talking about no case against him. If he now says reopen the case, does that not mean now that he's admitting that?
Under Section 36, he has a right of defense. So he has a constitutional right to defend himself. So he can predicate that under Section 36 of the Constitution because he has a right to defend himself. Whether the court was acting based on a repealed law can be a subject of final address. In fact, that was what I expected him to do. Enter your defense, then during your final address, get your lawyer to move that position of the law, that the law under which you are charged were repealed laws. In fact, that will truncate the entire trial. Now, the worrisome aspect of it is this. If judgment is entered against him, which for me I think is what's going to happen, because he has filed a motion. The second question is this: will this Court of Appeal step down the motion for hearing before 20th November? That is the question.
That's the big question.
So will the Court of Appeal slate that motion for hearing before 20th?
That's the big question.
Which is just the next 6 days.
Mr. Chilaka, let's come to you now. I mean, you're hearing this. We're not legal professionals, and you're hearing about this. What is your reaction to this? Well, shall we say the challenge that Barrister Nwabuko has pointed out this morning? How would you respond to this?
Well, you see, I always respect specialist opinion on something or input. He's a lawyer, I'm not. So, by common sense, I'm wondering while he was talking, why did his team of lawyers he's been working with not advise him against this? Also, I know that Nnamdi is a very stubborn man. He may also have been advised.
he's not Nnamdi too.
So he may have been advised and he would have chosen his own path. But whichever the case, if these things are what it is, then there's a big issue. But also there's a window, from what the lawyer said, that he can still ask to reopen his case. So I don't know if that has a limit. So maybe he's taking a shot at this one. If it doesn't work, he'll go that direction. But I always see lawyers around him, so he's still getting professional advice. And I don't know how blind all of them can be to this reality. I don't know.
I mean, this is a very serious case. We're taking it back to the last time we had you, Barrister Nwabuko, where we talked about one lawyer who wanted to come in and then he was sent out.
Yes,
maybe that would have been the lawyer that advised him. Right? So, but let's come to you now. This is serious. What you've pointed out this morning has a serious repercussion on this case concerning the detained leader. Now that things have gone the way they have, I mean, it's sad to be told that you have to cry over spilled milk, or to be told that, oh, you should have done this. I mean, that's the worst thing, especially when it has to do with a charge such as terrorism. What do you think would be the aftermath of this? Will Justice James Omotosho still deliver judgment on November 20th? And if he does, what could it mean?
Justice Omotosho will deliver judgment unless the Court of Appeal stops him. And before the Court of Appeal will stop him, the Court of Appeal must have sat, hear the application of Nnamdi Kanu, and then giving a judgment or a ruling in line with the prayers in the application. The Court of Appeal can sit tomorrow and still refuse the application. There's no law that says that every application was given in favor of the applicant. So the Court of Appeal may still sit tomorrow and refuse the application at the Court of Appeal, and Justice Omotosho will enter judgment because Mazi Nnamdi Kanu has no defense. Like I said, if we hear me, let him enter his defense. Let him bring an application before the Federal High Court to reopen his case. The court will not shut him down because he has every right under Section 36 to make his defense. In fact, if he files an application, is taken, he will be allowed to. That will buy him time to perfect his appeal at the Court of Appeal. While the appeal is still on, while his defense is still on, he can then move his motion when he has ample time, and the Court of Appeal can, if the Court of Appeal agrees with his application, stop the trial. Otherwise, by 20th of November, he will be convicted because there is no defense in this case.
If things don't go as planned, and November 20th, Justice Omotosho still delivers judgment, and if Mazi Kanu is found guilty, what are we looking at?
Well, then he cannot appeal. That's all. if he's found guilty,
exactly. I'll ask,
he cannot appeal,
Yeah,
but then as a convict.
Okay, Mr. Chilaka, go
okay,
ahead.
I want to ask the council, yeah. The laws that are repealed, that Nnamdi is pointing at, should the judge, going by the right thing, the right practice, should he be able to sentence him based on those laws?
Let me explain that. There are two things now. Okay. One is that he has a perfect window to point out that fact. And that can be taken at address. In fact, it would have been in his favor. Because if you watch the demeanor of the court, remember, he had brought an application of no case submission, which simply means that he believed that the prosecution doesn't have enough evidence to convict him. Now, the court has looked at the evidence on record, and the court believed that there's enough evidence to convict him. That was why the court refused his application of no case submission. So the court has already believed that he is guilty as charged. Now, he has opportunity of giving his own side of the story to truncate the evidence of the prosecution. Now, assuming that the law was repealed, now, after the trial, he will write what we call a final address. There he will argue the issue of law, that all those laws were repealed. But let me announce to you, those laws, that particular law was repealed. But there was a saving provision that every matter that was already in court before the repeal of the law will continue as though it was made under the new law. That is what that law says. The Terrorism Prohibition Act of 2022 made a provision, a saving section that says any matter that is ongoing before the law was repealed will be deemed as though it was made under the 2022 law.
Would Mazi Nnamdi Kanu's case classify as one that would still be...
Of course, that matter was made under the old law, but the matter was already ongoing before 2022. If you recall, Nnamdi Kanu was rearrested in 2021 and the matter was charged to court before 2022. So the matter was already ongoing, straight up to the Supreme Court, that remitted it for a trial, back to the Federal High Court. So the matter predated 2022. So it is classified as a matter that was ongoing before 2022. So that law, even though it repealed the former law, it saved matter that were already in court before 2022.
But didn't his lawyers know this before they were...
Chilaka has already pointed out that he doesn't listen.
Because
he has already pointed out.
It's an uncomfortable revelation. If you're right,
because as long as I'm concerned,
it's an uncomfortable revelation that you're making.
I read that law back to back. I think, in fact, it's Section 98. Section 98 of Terrorism Prohibition Act 2022 made a saving provision. Section 98 is on record that every matter that is ongoing before the new law will be deemed that, because if it is not done, that means a lot of matters in the court will be thrown out.
Didn't Aloy Ejimako know? Didn't the lead counsel...
They must have advised him. Remember, he told to start representing him. That is the issue.
You know something, I'll say something. It's to be a leader. In fact, to be a human being successfully, you have to listen to people, because you cannot see all around. You can only see things in front of you. So some other people need to help you to see your back. You know, that's one part of Nnamdi's personality I really get worried about sometimes. You know, I'm totally in support of his release. Right. Because as far as I'm concerned, he has done nothing.
All of us are.
No other person has done. I mean, people have done worse things and they are walking free. You know, so, but the idea, when I heard he dropped his Lego team, you know, you must respect professionalism. You can't know it all. Common sense does not work with law. There are technicalities. I would have argued this differently, but I'm not a lawyer. Now we're getting the technical aspect of what's going on.
Real technical.
The law is repealed. And there was a clause somewhere saying that the case is that it's just like you're changing a policy about secondary school, and you're saying those who are already in secondary school at the time this law is being changed, that they must graduate based on the old law they already got into it with. That's what it is. Simple English. You know what I mean? That's why we all have legal advisors to open this kind of windows for us. You could have read that and wouldn't have made any sense out of it. So it's quite a shame. But like he said, I know the case is not going to die there. Even though he's even convicted, there's going to be an appeal, obviously. And it's going to come another long process. But it's quite a shame that we're living in this kind of country. It's just a shame.
But from the beginning, I know that, you know, they always talk of fruit of the poison tree. If the evidence is gotten illegally, it cannot be used in court. How is it that, based on the manner in which he was arrested, this case is still in court? Shouldn't that have been validated?
Yes, exactly. That's the corruption we have in our system that is worrying.
See, that is why I said he should have entered his defense. It is in public view, right? Is it on record in the court? In the court? Okay, that is the issue. I had wanted him to give his defense, because it would have been in his defense that he would have espoused how he was kidnapped. That is not on record.
Was that not put forward before?
How?
When he was released and even awarded damages a while back?
It was not a part of the trial. Because if the court is giving judgment, it will not give judgment based on application that we are heard and disposed of. The court will look at the trial. So it is not in evidence. It was an application. Albeit, the Court of Appeal granted that application, of which the Supreme Court refused that application. If you remember, the Supreme Court did not agree with the Court of Appeal. You see, those are the issues that I have with Aloy Ejimako. Because the Court of Appeal was in tandem with Nnamdi Kanu that he was extraordinary rendition. But the Supreme Court disagreed. That was why he remitted the matter for trial. So it was left for Nnamdi Kanu to put it on record during trial, saying, I was so placed in Kenya, I was kidnapped, I was beaten up, I was stripped, I was starved, I was unjustly treated. It will be now part of the record. Now, the prosecution witness will have opportunity of cross-examining him, and the more they cross-examine him, the more those things will be on the record.
Will it matter?
It will matter.
If the Supreme Court did not see what the Court of Appeal saw, then something is wrong.
That's my
Something
point.
is wrong.
If the appeal court,
Because there's a bias.
before the appeal court,
Now,
and the appeal court is saying you are right,
now
everybody agrees.
let me explain how the law works.
Everybody agrees they brought it, and the Supreme Court says no.
Now, let me explain how the law works. You know, sometimes the court will not take matters in motion seriously, because application, that is motion, has not been subjected to the fire of cross-examination. It's simply an affidavit that somebody deposed to, and there's a counter affidavit. Now, what the court will take more serious is evidence by a party, which will give the other lawyer opportunity of cross-examination. Now, I think that the Supreme Court, not that they do not agree with Mazi Nnamdi Kanu, but they would have preferred a situation that it will be an oral evidence by Nnamdi Kanu and then cross-examination by the lawyer on the other side. So the court will give more weight to evidence than to affidavit. So it's not as though the Supreme Court does not believe that it was extraordinary rendition, but it's necessary that the matter will go to trial so that Nnamdi Kanu will give his own oral testimony and be cross-examined. That was what I expected him to do. He would have told his story. He still has a window to do that. Tell your story. Talk about what happened. Now, Justice Omotosho will have no option than to record it. Now, during the final address, it will not become part of the judgment. That would have been a perfect way to anchor the issue of judicial of the court.
I have something tells me.
Ask you something.
Yeah.
I want to take us away from the technicality now. When we all sat here, you and I even sat here before the 2023 elections, and we looked at all the evidence, and it was looking good for Labour. And the Supreme Court threw it out. So my question is, to add to what you're going to say, do you have faith? Because the reports I keep getting around is, nobody really thinks that, they think Mazi Nnamdi Kanu is reacting because there is no process that will give him a result the government does not feel like giving him. Let me
You know, that's the funny thing about law, and maybe our constitution that is faulty. You know, there's always a window to do the wrong thing. I don't know if it was intentionally created or just, faulty design of the constitution on our law.
A window to do
There's always a window to do. Yeah, there's always a window to do the wrong thing based on technicalities of the law. Because I don't understand, in a country where the law is the same and it's a healthy law, why a Supreme Court will see something. If the Supreme Court thinks there's something wrong with what the appeal, so it should be clear for us all to see and understand. This blind war of taking decisions, and this person sees, in Nigeria, 10 courts will see a case and they'll see 10 different things. That's something wrong with the law. Because if it's the same law, they should be seeing the same thing. My view because the law is made for us, not us for the law. So if it's for us, why can't we should be able to understand whatever they're doing in there. Or they should be able to find a way to explain to us. So Nnamdi has lost confidence in the system. And it's obvious, he says it every day without bias. So he doesn't believe that he's going to get any fair trial. I'm sure that's why he chose not to waste his time. It may not be to his best interest. But it's quite unfortunate that our country, me personally, I don't believe in our judicial system. I'm sorry. Our main problem in this country is the judges.
All right. I mean, we have really said a lot about this matter on the program today. Quite uncomfortable discussions for those who support the detained IPOB leader. But we'll continue to watch and see how everything cascades ahead of November 20. If any of the courts will be able to stop the Federal High Court, we'll watch and see. But judging by what Barrister Nwabuko has said, it seems rather unlikely. But we'll watch and see.